Forbes' title is rather brutal. Feds walk into a building, demand everyone's fingerprints to open phones.
No.
And so I'm just going to read the top of the story, and two well-known legal experts were consulted for their opinion. So Forbes wrote, in what's believed to be an unprecedented attempt to bypass the security of Apple iPhones, although actually the warrant specified 4 different brands, all known to have fingerprint readers. So the law enforcement officials didn't even know which phones people might have.
Wow. So
they just blanketed it. I mean, that's the big concern. Not only is there a concern with forced use of biometrics, which the argument has been is not constitutionally protected, but in this case, it's also just the breadth of this warrant. So, so the security of Apple iPhones or any smartphones that uses fingerprints to unlock. California top cops asked to enter a residence and force anyone inside to use their biometric information to open their mobile devices. Forbes found a court ruling dated May 9th, 2016, in which the Department of Justice sought to search a Lancaster, California property. But there was a more remarkable aspect of the search. As pointed out in the memorandum, quote, authorization to depress the fingerprints and thumbprints of every person who is located at the subject premises during the execution of the search and who is reasonably believed by law enforcement to be the user of a fingerprint sensor-enabled device that is located at the subject premises and falls within the scope of the warrant, unquote. The warrant was not available to the public, nor were other documents related to the case. According to the memorandum signed off by U.S. Attorney for the Central District of California, Eileen Decker, the government asked for even more than just fingerprints. Quote, while the government does not know ahead of time the identity of every digital device or fingerprint, or indeed every other piece of evidence that it will find in the search, it has demonstrated probable cause that evidence may exist at the search location and needs the ability to gain access to those devices and maintain access to search them. For that reason, the warrant authorizes the seizure of passwords, encryption keys, and other access devices that may be necessary to access the device. Legal experts were shocked at the government's request. Marina Medvin of Medvin Law said, quote, they want the ability to get a warrant on the assumption that they will learn more after they have a warrant. Essentially, they are seeking to have the ability to convince people to comply by providing their fingerprints to law enforcement under the color of law because of the fact that they already have a warrant. They want to leverage this warrant to induce compliance by people they decide suspects later on. This would be an unbelievably audacious abuse of power if it were permitted. And then Jennifer Lynch, who's the senior staff attorney at the Electronic Frontier Foundation, added, it's not enough for a government to just say, we have a warrant to search this house, and therefore this person should unlock their phone. The government needs to say specifically what information they expect to find on the phone, how that relates to criminal activity, and I would argue they need to set up a way to access only the information that is relevant to the investigation. The warrant has to be particular in how it describes the place to be searched and the thing to be seized and limited in scope. That's why if a government suspects criminal activity to be happening on a property, and there are, say, 50 apartments on that property, they have to specify which apartment and why and what they expect to find there. And then she concluded saying, we've never seen anything like this. Now, nobody really, because this is not public, nobody understands the details. But from our technical perspective, if we were to sort of reverse engineer what may explain this, because I was thinking about, like, okay, first of all, the concern is this is now what law enforcement, this is apparently law enforcement's, maybe another test, but their reaction to the famous, iPhone fingerprint hack problem, where they're just saying, okay, fine, we're just going to, since the courts have said a password coercing a password constitutes self-incrimination, which is protected by the Constitution. We can't do that. But the courts have also previously said biometric information is not protected. So law enforcement just saying, okay, fine. We want specifically the warrant to include, to give us the right to force anyone in this location to unlock their phones. So again, the generality of this makes me think it's tied to an IP address. That is,
interesting. Right? Yeah, that makes sense. Yeah. They know it's this building.
Well, or this residence. It was actually a house. And so they probably found some traffic which they believed represented, in whatever it was, criminal activity. They got the address from the cable provider or whoever provides internet service. So now they know that it is a device, and they just presume probably a cell phone, if not maybe a PC, but those don't tend to be locked the way mobile devices are. And so they wrote the warrant to give them permission when they get there to force everyone to let them look inside their phones, presuming that one of them will have been the end point of that electronic communication.
Yeah, wow.
Which in my mind doesn't excuse it, but it sort of explains, like, probably what was going on.
So then that begs the question, because all of us now, I hope, have fingerprint protected phones, what you should do. And it seems to me the easiest thing would be when the feds pound on the door, besides flushing all the drugs down the toilet, you'll want to turn your phone off, because at least all the phones I've used, iPhone and Google phones, once you turn it off, the fingerprint won't unlock it. You'll have to then enter your passcode, which Correct. They can't reasonably demand. I mean, they can demand, but not reasonably.
Correct. That or call your attorney and impose a 48-hour delay.
Oh, there you go. And that'll
do it
too.
That's the other thing that will cause that to expire.